Today, all eyes will be on a courtroom in Collin County as the man convicted in a deadly high school track meet stabbing makes a new plea. Back in June, a jury convicted Carmelo Anthony of murdering Austin Metcalf.
Now his attorneys are pushing for a new trial.
Our Janelle Fort live at the courthouse this morning with what's at stake today. Janelle?
Well, Dee and Matt, before Carmelo Anthony's attorneys can really get into their argument for a new trial, they first want a new judge, and that is what today's hearing is all about. It starts at 9 o'clock this morning. So I have our legal expert, Todd Shapiro, here with us this morning. Todd, I know that you covered this the first go around. I know you're going to be in the courtroom today. Can you walk us through what we can expect in today's hearing?
Sure. So today and tomorrow, kind of a two-step process here on this case. First, the defense has filed a motion to recuse Judge Roach based upon maybe some comments that he might have made post-trial, as well as potentially not allowing the media in the first time. So there are a few points that they're trying to bring up to have him recused and removed from the case. There's a visiting judge that's sitting that will listen to the evidence, whatever's presented by the defense, and then make a ruling and decision whether Roach gets to continue on the case or not.
In your legal opinion, do you think that he is going to be recused?
I don't believe so. Based on anything that I know, I think it's a high burden that the defense has to prove. I think they have to climb a pretty high mountain to get there. And I just don't see that Roach did anything other than run a completely efficient and speedy trial and got everybody a fair trial. Both sides got a fair trial. And so I don't really see how his comments post-trial would have an impact on whether or not he gets to continue to serve.
So we will end up seeing who ends up on the bench for tomorrow, which is something completely separate. They'll be looking at whether or not there's a new trial. Walk us through how that process
goes.
Goes.
So once they make a determination of which judge gets to hear it, then tomorrow is the actual hearing to determine whether or not that Mr. Anthony gets a new trial based on the motion for new trial. It's kind of the first step in the appeals process. Another high mountain to climb. They got to prove that there was evidence that was either excluded or they have new evidence or something they want to present that was not presented in the first trial to convince whoever it is, either Judge Roach or the visiting judge, that Carmelo, in fact, deserves another opportunity, another trial. But it's a tough burden to overcome. It does not happen very often.
And then real quick, before I let you go, what is the likelihood, in your opinion, that there will be, in fact, a new trial?
Well, I mean, again, I don't know what's going to happen or what's going to be presented, but I think it's a tough argument to sell from Carmelo's side, and I would be surprised if a new trial is granted, absent the idea that they bring in some new evidence or bombshell information that could change the landscape. As of right now, to me, what's been presented, I just don't see it for a new trial.
Well, thank you so much, Todd.
Sure.
I know you'll be inside.
Carmelo Anthony will go to court this morning seeking a new judge and a new trial.
He's serving a 35-year sentence for fatally stabbing 17-year-old Austin Metcalf at a track meet last year. Peyton May is live this morning in McKinney with a look at what to expect in court today. Peyton.
Yes, Brandon, Anthony has a new legal team of well-known civil rights and criminal defense attorneys. Today, they'll be requesting a new judge, and tomorrow, they'll be asking for a new trial. Now, in June, Anthony was found guilty of stabbing 17-year-old Austin Metcalf to death at a Frisco track meet. A jury sentenced him to 35 years in prison. Now, Anthony's representation wants the judge who presided over that June murder trial, Judge John Roach, to be removed from all his future proceedings. Judge Sid Harrell, who presided over the first Uvalde shooting trial, is traveling to McKinney to hear arguments regarding that request. Anthony Farmer, an attorney not involved in this case, has previously worked on cases where a judge has been recused. He says there could be issues moving forward depending on what the judge has previously said.
The judge already feels that and has made comments and admitted that he feels the first trial was fair, then the movement presenting a motion for new trial is almost moot and void because the judge has already said, I feel it's fair.
What happens today will directly impact a hearing tomorrow. In that proceeding, Anthony's attorneys will request a new trial, raising constitutional and legal challenges to the original trial. They want those issues to be decided by an independent judge. Now, the hearing will begin at 9 a.m. and we will have a reporter inside of the courtroom to bring you updates on our website, fox4news.com, along with on the Fox Local app. The public will be allowed to go inside of the proceedings, but cameras will not be allowed inside. Reporting live at Collin County Courthouse, I'm Peyton May for Good Day.
Carmelo Anthony's appeal hearings is the next chapter in a nationally publicized trial happening locally beyond these courthouse steps.
There's too much at stake. One of the biggest trials of possibly the decade. It could be the biggest trial of your career.
Anthony was convicted of murder in the stabbing death of Austin Metcalf, sentenced by a jury to 35 years in prison. This week, there is one motion for a new trial, but first, a motion to replace the judge, Judge John Roach.
We believe that based off of the interview that was done, that he could not be fair and impartial.
Anthony now has a new defense team that argues the judge's comments made in a WFAA interview after the trial raises red flags.
As long as I follow the law, I sleep well at night.
A visiting judge named Sid Harrell will make the decision to recuse on Wednesday, and that determines who sits on the bench Thursday for the motion for a new trial, where the defense has raised a number of issues from the trial. To begin, the breakdown of an unwritten gentleman's agreement between both sides.
I don't know if I would necessarily do a gentleman's agreement. There's a lot that could go wrong with it, and I think it did.
Bonita Parker is a longtime defense attorney. Not a party to the case, she says these agreements do happen.
That was the state's position. What happened under the tent at that track meet?
In this case, cell phone records, disciplinary records, character testimony of Austin Metcalf and Carmelo Anthony were mostly excluded.
We're arguing that the dispute regarding the agreement did impact the outcome of the trial.
Defense attorney Mike Howard, state's attorney Bill Werski could be called to testify. It will come up. How much time did Anthony have to decide whether to testify? Was it 5 minutes? Was it 30?
We were actually looking forward to see what Carmelo Anthony would have to say.
The defense will argue the public did not have legally sufficient access to this trial. Limited seats, no cameras. They'll also argue the judge's decision to dismiss 3 black jurors. The state argued to strike them because they were educators.
We don't strike people for no reason.
The judge has 75 days from sentencing to rule on a motion for a new trial. We are told that is next Monday.
We may not hear anything at all. If he does nothing, then it's just by operation of law denied.
The motion for a new trial could get punted to a higher court, the Texas Court of Appeals.
Out of 100 trials, how many would you say are granted a new trial?
Maybe none, but maybe one.
We're told Carmelo Anthony will attend the hearings. It's unclear if the Anthony and Metcalf families will attend. They are not obligated to.
They're always going to live it again.
And again.
And again.
It's the next chapter in this case, and it's not a short one. Appeals take time, and there is a lot of waiting.
Oh, yes, it could take years. It could take years.
In Collin County, I'm Jobin Puniker.
Today, all eyes will be on a courtroom in Collin County as the man convicted in a deadly high school track meet stabbing makes a new plea. Back in June, a jury convicted Carmelo Anthony of murdering Austin Metcalf.
Now his attorneys are pushing for a new trial.
Our Janelle Fort live at the courthouse this morning with what's at stake today. Janelle?
Well, Dee and Matt, before Carmelo Anthony's attorneys can really get into their argument for a new trial, they first want a new judge, and that is what today's hearing is all about. It starts at 9 o'clock this morning. So I have our legal expert, Todd Shapiro, here with us this morning. Todd, I know that you covered this the first go around. I know you're going to be in the courtroom today. Can you walk us through what we can expect in today's hearing?
Sure. So today and tomorrow, kind of a two-step process here on this case. First, the defense has filed a motion to recuse Judge Roach based upon maybe some comments that he might have made post-trial, as well as potentially not allowing the media in the first time. So there are a few points that they're trying to bring up to have him recused and removed from the case. There's a visiting judge that's sitting that will listen to the evidence, whatever is presented by the defense, and then make a ruling and decision whether Roach gets to continue on the case or not.
In your legal opinion, do you think that he is going to be recused?
I don't believe so. Based on anything that I know, I think it's a high burden that the defense has to prove. I think they have to climb a pretty high mountain to get there. And I just don't see that Roach did anything other than run a completely efficient and speedy trial and got everybody a fair trial. Both sides got a fair trial. And so I don't really see how his comments post-trial would have an impact on whether or not he gets to continue to serve.
So we will end up seeing who ends up on the bench for tomorrow, which is something completely separate. They'll be looking at whether or not there's a new trial. Walk us through how that process.
No peace. There'll be no peace. There'll be no peace until there's justice. Until there's justice. There'll be no peace. There'll be no peace. There'll be no peace until there's justice. Until there's justice. There'll be no peace. There'll be no peace.
It's your girl, Neek, and I am here outside of the Collin County Courthouse. Now, we have been here since early, and I already have my number. I am number 7 in line. So I'm going to be bringing you guys the updates on the Carmelo Anthony case. I'm going to be letting you guys know what's going on in the hearing, and I'm going to be giving you guys truthful reporting. Now, as you guys seen the footage that I dropped on my Facebook and my YouTube of the surveillance of last time that we were here, I matched it up with some of the reporting from some of the other individuals, and you've seen how what they said was a lie and what I told you guys and reported to you guys was the truth. And so just like last time, we're going to give you that truthful reporting on the Carmelo Anthony hearing. And make sure to check my page, and if your notifications are not on, make sure you turn your notification bells on. Okay. All right, and we got Gerald from the NC beat here.
Number 6.
Period. Number 6. I'm number 7. And we're going to be up in that thing. They gave us our cards, so I'm not lined up in the line anymore because my number is here.
Okay.
Okay. So
we're gonna take our rightful place.
Yeah, we're gonna take our rightful place in line, and we're gonna give you the accurate and truthful report. Okay. Period. Hey y'all, it's your girl Neek, and I am here outside of the
Good afternoon. It's the Fit Lawyer ATL, and we are live. I am in Frisco County, Texas, ahead of the Carmelo Anthony hearings this week. If you've been following any of our coverage on the trial, which started the day of the verdict into now, you know that Carmelo Anthony is having 2 hearings this week. Tomorrow, he is having the motion to recuse Judge Roach. Thursday will be the motion for new trial, and we will be there in person, all right? There'll be streaming, there'll be some video streams of the hearing as well as audio streams of the hearing. There'll also be an overflow room for Wednesday. We know that for Wednesday. We have not been told what's going to happen yet for Thursday. I have been in communication with the public information officer for this hearing for the last month, and the updates to add the overflow room and the audio feed were just added a couple of weeks ago. But like I say, they're just for Wednesday, because if Judge Roach is recused, then Judge Hall will continue to hear the motion for new trial on Thursday. But if he denies the motion on tomorrow and Judge Roach is not recused, I can only imagine Judge Roach could possibly hear the motion for new trial on Thursday. So the seating arrangements, overflow accommodations have not been announced yet for Thursday, because it depends on what judge will be hearing that case. If you're new here, like, share, and subscribe. This is the Fit Lawyer ATL. I am a 20-year criminal defense and personal injury attorney in Atlanta, Georgia. If you ever get arrested for a crime or involved in a crash in Georgia, our information to contact us is in the description. All right, y'all. So as you know, I am standing outside of the Kuykendall Stadium where the murder of Austin Metcalf occurred last April 2nd. I say that because Carmelo has already been convicted of murder. The trial on that case was this past June. The conviction came down on June 9th. Carmelo had 30 days from that point to file his motion for new trial. That was filed by his new appeals team led by Russell Wilson on July 7th. We covered that extensively on the channel, so make sure you go back and check out those lives. The defense team filed also at the same time a motion to recuse Judge Roach. Not sure if you're familiar, but 2 days after the conviction on this case, Judge Roach went on TV, a news station here in Texas, and did an interview. All right. Strange, because we haven't seen that a lot, right? Where he did an interview talking about this case. He did an interview talking about Carmelo. He even gave his opinion about how the jury performed on the case, and he thanked the entire county, everyone, for working for the last 10 months to get security and everything in place for the trial. So the defense team is saying, wait a minute, Judge, you seem a little biased now. You actually made statements that you support the jury verdict. He also made statements that Carmelo is a good kid and that he thinks he just made a mistake, and that now he's pretty sure that he understands the consequences of his actions, which mean you kind of agree with the verdict. You're speaking on it. So you're presenting a bias is what the defense is arguing. And so they're asking for him to be recused from this case, because although the conviction came down and you sentenced him, there are still post-conviction efforts that the defendant can take, and the judge that had the case hears those, and so they're like, wait a minute, Judge, you're showing a bias, so we want you off the case. So that is the first hearing up. Judge Hall will be hearing that. How it works when you file a motion for new trial, the judge that is filed against reviews it, makes sure that it's filed in time, that certain requirements in it are there. Then they decide, could someone read this motion and they agree with the defense? Does it show a bias? If they say that, well, if you agree with the defense, it could, then the judge has 2 decisions. He can then decide to recuse himself. Judge Roach did not do that in this case, or you can send that over to an administrative judge to then assign it to a new court, and that's how it is before Judge Hall. Okay, so Thursday's hearing is the motion for new trial. Carmelo Anthony's defense team filed this motion, and they raised 4 legal arguments. Their first one and strongest argument is that Judge Roach placed restrictions on this courtroom. I don't know if you recall the gag order that was issued in this case very early on, June of 2025. And then there was in April order that restricted who could come into the courtroom. It stated that they will only allow 9 legacy media into the courtroom, Carmelo Anthony's family, Austin Metcalf's family, and the public. It only left about 27 seats for the public. On day 1 and 2 of the trial, which was voir dire, they allowed an overflow room for that, right? And so that other people were allowed, there were more than the 27 people allowed into the public, and then day 3, when the actual trial started, they shut that down. They closed it, was no hearings on anything, and so therefore it only allowed about 27 people from the public that they were able to rotate in, first come, first serve. What the defense argues is that this was a restriction placed on the courtroom, and because this restriction was put in place, the law through a Presley case versus State and Waller versus State, which are cases from DeKalb and Fulton County of Georgia, where I'm from, say that the judge has to do certain things when this restriction is placed on the courtroom. He has to make certain findings and put these on the record. Guess what? No one in this case asked for the courtroom to be closed. The judge decided on this on his own. So there was no hearing, right? There is no record of this decision. There was no thought process put into it as far as what's the overriding interest here? Why do I want the courtroom closed to the public? Why am I putting these restrictions in place? Are there any alternatives? That discussion wasn't had because there wasn't a hearing. If you recall from Judge Roach's interview 2 days after the trial, he actually stated, maybe I should have allowed an audio feed, then people wouldn't be guessing about what the evidence was that was presented at trial, which we can now see because we have the trial transcripts, and we're going to be breaking those down on the channel. So make sure you like, share, and subscribe. But once those restrictions are put in place, did you make those considerations? Did you put all that stuff in your order? Did you put those findings of the alternatives that you considered and why you didn't follow them? And y'all, we covered the order on our channel, and it seems kind of bare to me, right? It seems like the judge didn't put some of those legal requirements in his order. And guess what Presley says? Presley says that that Sixth Amendment right to a public trial, and people get confused, right? They're like, look, some people were there, so it was public. But no, if there are any restrictions placed, the law says that, and this is the defense's argument, that you have to do these findings on the record, and there weren't. And so what Presley says is that if that's violated, if your Sixth Amendment right to a public trial is violated, guess what? It's enough to overturn your conviction, and that is the big deal for Thursday's hearing. Okay, so that's the defense's biggest argument, the first one in their motion, and I think it took up about 30 or 40 pages of their 58-page motion. Next came the argument that this gentleman's agreement that the state and the defense entered into, that they basically try this case clean, that they wouldn't enter. Oh, I'm sorry. Pause. All right. Good afternoon, Fit Lawyer ATL back. I had to relocate from the track to outside of the Collin County Courthouse. As you recall, I am here live in Collin County, Texas, ahead of the KARMELO Anthony hearings that will occur here tomorrow and Thursday. As I was saying, Thursday's hearing is the motion for new trial. And KARMELO Anthony's appeal team, led by Russell Wilson, filed a motion for new trial on July 7th. In that motion, they raised 4 legal issues regarding the motion for new trial. Their strongest argument was that the judge in this case, in the trial court, placed restrictions on the courtroom of who could attend, who could come into the hearings. By doing that, they make a legal argument that the law, Presley versus State and Waller versus State, cases out of Fulton County and DeKalb County, Georgia, require that legal findings be put on the record as to why these hearings were closed. And so they're saying that that was not done, and so therefore the motion for new trial should be granted. The Presley case actually states that that Sixth Amendment right to a public trial is actually something that, if violated, deserves a new trial. And so that is the argument that they led with. That is their strongest argument that they're raising in this motion for new trial, followed by the argument of the breakdown of the gentleman's agreement. And if you recall, we broke that down on the live, where the state and the defense agreed to try the case clean. They agreed to keep out bad stuff about KARMELO Anthony and his past, is the same for Austin Metcalf and his past, and to just try this case based upon what happened under the tent. However, the defense argues that once it came time for KARMELO to testify, the state reneged on this deal. The state reneged on this deal and said that we never intended it for it to cover KARMELO. And so there was this defense says they had 10 minutes. I think the state has come out and spoken and said actually he had 30 minutes to decide. But either way, he had to make a decision of whether or not he would testify, and he chose not to testify at that time. So we didn't hear from him. Also, they raised the argument that the provocation argument that the state put forward, that KARMELO actually provoked this encounter to make Austin respond so that he could then therefore stab him with this knife he had, that that was not presented correctly to the jury, that was not a valid argument for them to consider, and it was an invalid jury instruction, and they are also asking for a motion for new trial based on that. Their fourth argument is that all of those things in totality equal an unfair trial for Carmelo, and that he deserves a new trial based on those reasons. So tomorrow, Wednesday, is the motion to recuse Judge Roach, followed by Thursday's motion for new trial. As you can see, we are here live in Collin County, and I will be inside of the courtroom for those hearings. I'll be reporting back live in between the breaks and in the evening to give you a recap of what occurred. So make sure you like, share, and subscribe to the channel. The Fit Lawyer ATL is in the building in Collin County, Texas, to be present for the hearings.
All right, blessings, and grand rising, Levi family. As you see, what I have shown you is a host of people who are actually outside and at the hearing today. So we're going to be checking in and out of some of these content creators platforms that I have located. As you see, if y'all look at my thumbnail, I'm looking through. This is what I do. I get good feeds. I get a lot of information, and I want to share with you in real time. So this is what to you. This portion is brought to you by Times Network. Okay, they are out there live. I've been waiting since 8 a.m. watching them to get on. So while we're watching in real time and I'm going between different platforms, I want you guys to listen to the podcast portion of yesterday's live that broke down some of the things that happened in the last 2 days of the trial, highlighting the judge's instructions to the jury, which there are major issues with, as well as allegedly how the judge entrapped the jury, forcing them to make a decision. All right, so we're going to let you listen to that while we watch live to see what's going on at the Carmelo hearing today. I want to say thank you so much for being here with Miss Grace. Again, this was a hard morning. Again, I started off just thinking about my children, thinking about the young adults, me being a parent, a mother, an auntie, and having to live through this. So I want to send love and blessings to Carmelo Anthony family, as well as the Metcalf family. They lost a son, as well as today we have to send a special shout out to Nolan Wells, because today would have been the day that he turned 19 years old. So for the Black community, this is monumental moments for us, because we are standing together in unity, no matter where we come from, what part of the diaspora that we come from. We are here to band together to get justice. Okay, so let's play this. Let's listen to the podcast as we wait to see what happens live outside of the Carmelo Anthony hearing. Please hit the like button, like, subscribe, turn your notifications on. As you know, I am not monetized, won't be. All I'm here to do is spread the truth.
Justice system is this grand public monument, right?
Oh, definitely. Very transparent.
Yeah, exactly. We pictured these old courthouses with heavy wooden doors flung wide open to the public square, the grand marble columns.
Right. Viewing galleries just packed with citizens.
Right. Because the entire architectural philosophy of a courthouse is built around this idea that justice is something you can, and honestly, that you must see happening. If the state is going to take away someone's freedom, they have to do it in the absolute light of day.
Yeah, transparency isn't just, a best practice in the legal system. It is the load-bearing pillar of the whole structure. The process is supposed to be completely visible to anyone who just wants to walk in off the street and watch the gears turning.
But then you encounter a case where those heavy wooden doors get deadbolted.
Right.
And the windows are tinted, the official record is sealed, and suddenly that grand public monument feels a lot more like a walled fortress.
Which is a huge problem.
It is. And that's what we're getting into today.
Welcome to today's Deep Dive. We are so thrilled to have you with us. Today, our mission is to analyze the core claims demanding a complete retrial in a very high-profile Texas murder case.
And we have a massive stack of sources on our desks for this one.
Oh, we really do. We are looking at the actual defense briefs, the appellate motions, court transcripts, and even transcripts from local media interviews.
Yeah, it's a really compelling body of source material, mostly because it forces us to confront what happens when the mechanics of justice, kind of retreat into the shadows.
Right.
When we talk about appeals, I think people often assume the argument is about whether the jury made the right choice, like whether the defendant is actually innocent.
Sure, like a whodunit.
Exactly.
Yeah.
But an appeal of this nature is entirely different. It asks whether the process itself was fundamentally structurally fair.
So let's just lay out the foundational facts impartially so you, the listener, know exactly what we are dealing with here. We are looking at the state of Texas versus Carmelo Sincere Anthony.
Carmelo, who was 19 years old at the time of the trial, was convicted of the murder of Austin Metcalf. This was following an altercation at a high school track meet, and he was sentenced to 35 years in prison.
And throughout that trial, the defense argued self-defense.
They did. But now, the appellate defense team is demanding a completely new trial. They're asserting that the original proceedings were just compromised by the severe escalation of unfairness that infected basically every level of the process. So, okay, let's unpack this. We're going to trace this escalation, and it really starts before you even step foot inside the courtroom.
Yeah, the defense's foundational argument here is that the court instituted this access regime that foreseeably and systematically excluded the public. They are alleging a structural public trial violation under the Sixth Amendment.
And the details of this access regime in the defense briefs are just staggering to read. It began 10 full months before the trial even started.
With that gag order, right?
Exactly. A sweeping gag order. Nobody with first-hand knowledge of the case was allowed to speak to the media for 10 months. But it's the physical access to the courthouse that really paints a vivid picture.
Oh, the curfew.
Yes. The court instituted an overnight curfew on the entire courthouse campus, running from 11 p.m. to 6 a.m.
Which you don't see every day.
You really don't. And why did they do it? Well, because out of a courtroom that held roughly 70 people, only about 24 seats were actually made available to the general public. So people who were desperate to get a seat just began lining up in the pre-dawn hours.
And law enforcement was actually stopping people at the parking lot until that 6 a.m. curfew lifted. So you essentially had this chaotic line forming in the dark, administered without any clear published standards on, like, how seats would even be distributed once the sun came up.
It sounds less like a public institution and more like an exclusive nightclub, like with a bouncer holding a clipboard at a velvet rope.
That's a really good way to put it.
Because imagine your loved one is on trial for their life, and you can't even get in the building. According to the briefs, the defendant's own grandfather and his aunts were excluded because the court instituted a strict 8-seat cap on the family.
Wow.
And there's this specific anecdote in the filings about a woman named Thelma Anderson.
Oh, yeah, the line jumping situation.
Right. She arrives super early. She's 7th in line in the dark. And somehow, inexplicably, she gets bumped to 35th and completely misses the morning session.
Just bumped back with no explanation.
None. And another woman is physically removed from the courthouse because of the expressive content of her clothing.
Well, and a crucial element the defense points out here is the overflow room, because the court did initially provide an overflow room with a live video feed during the jury selection phase.
Okay, so that seems reasonable, right?
It does, but then on the very first day of actual testimony, like the exact moment the presentation of evidence began, the court just quietly eliminated that overflow room.
Just turned it off.
Completely. There was no announcement in open court, no written order justifying the closure, no findings placed on the record. The feed was just gone. No video, no audio.
So if you were one of the dozens of people turned away at the door, you had zero way to know what was happening inside.
Exactly.
But I do want to pause here for a second just to play devil's advocate, because judges do have to manage security and space, right?
Yeah.
They can't realistically let 1,000 people cram into a 70-person room just to satisfy public curiosity. So I'm trying to figure out why this crosses the line from, standard administrative space management into what the defense calls a structural error that automatically demands a new trial.
Well, I mean, what's fascinating here is how the Supreme Court has structured this specific right. A judge absolutely can restrict access for security or space. But under a landmark precedent called Waller versus Georgia, if a judge is going to close the doors to the public, they must navigate a very strict two-pronged test.
Okay, what are the prongs?
First, they have to make specific on-the-record findings that justify the closure. And second, they must consider reasonable alternative.
Like, say, keeping that overflow room open, or just providing a live audio feed on a website.
Precisely. And the defense argues the judge did neither of those things on the record. And this is the mechanism of a structural error. Most legal mistakes are subject to what we call harmless error analysis.
Right.
If a judge accidentally admits a minor piece of irrelevant evidence, the appellate court just asks, did this actually change the outcome of the trial? And if the answer is no, the verdict stands. But denying public access without meeting those Waller requirements is treated totally differently. It is a structural error.
So it's kind of like a contaminated crime lab.
Yes, exactly.
If the entire lab environment is contaminated, you don't waste time trying to prove whether one specific DNA test was altered by the bad environment. The structure itself is compromised, so you just have to throw out all the results and start over.
That is a brilliant way to frame it. The secrecy itself is the injury here. The defense doesn't have to prove that the lack of public spectators actually changed the jury's verdict, because the Sixth Amendment right to a public trial doesn't just belong to the defendant. It belongs to you, the public.
Right.
It exists to serve as a check on the system, just to ensure the state isn't condemning citizens in secret.
And according to the filings, that culture of secrecy didn't just stay in the hallways with the locked doors. The defense claims it bled directly into the judge's chambers and, severely infected the legal strategy itself. They claim they were gutted by a broken off-the-record handshake deal.
Yeah, this transition from physical exclusion to procedural informality is really where the constitutional crisis deepens in this appeal.
The appellate brief refers to it as the Try It Clean agreement. So in early May, which is weeks before the trial began, the prosecution and the defense met in the judge's chambers. And crucially, this was off the official public record. They agreed they weren't going to use any character evidence or bad act evidence against either the defendant or the victim. They were just going to stick to the raw facts of the altercation itself.
Which is where the concept of detrimental reliance. Right. You altered your position to your own detriment based on an agreement. And the other party took the benefit and then completely pulled the rug out. In law, that creates a binding obligation, even if it wasn't a formal written contract.
That makes total sense.
Yeah.
And looking at the filings, the defense here gave up a massive amount of leverage based on that verbal promise.
Oh, huge amounts.
They had witness statements showing the victim had aggressive tendencies, like statements saying he got triggered and could be a bit aggressive at times.
Yeah.
And they intentionally didn't bring any of that up on cross-examination. Plus, they completely benched their expert witnesses.
Which is a huge sacrifice in a murder trial.
Seriously. They had a neuropsychologist ready to testify about the defendant's epilepsy and how it chemically affected his threat perception. And they had a forensic psychologist prepared to explain adolescent brain development and the fight-or-flight response. And they shelved all of it just to honor this unwritten deal.
Because their entire strategy was meticulously built around a very specific payoff. The defendant, Carmelo Anthony, was going to take the stand and testify about his internal perception of the threat, entirely free from character assassination. And in a self-defense claim, the defendant's state of mind is the cornerstone of the whole case.
But then comes the rug pull.
Right.
It's Monday, June 8th, the final day of evidence.
Yeah.
The defense has played by these unwritten rules for the entire trial, holding back their experts and their cross-examination. And right before the 19-year-old defendant is about to take the stand to tell his story, the prosecution suddenly announces that the agreement never contemplated a testifying defendant.
It's just wild.
It is. And they claim the defense already opened the door to character attacks because during opening statements, they mentioned that the defendant played chess.
Yeah, claiming that mentioning a board game opens the door to a person's entire character history is quite an aggressive legal leap.
It seems absurd. Like, playing chess opens you up to character assassination. So the judge steps in and says he has no mechanism to enforce an unwritten deal. And this is the part of the brief that really gave me pause. The judge gives this 19-year-old kid just 10 minutes.
Just 10 minutes.
10 minutes to decide the rest of his life. He has to choose whether to risk testifying and facing this barrage of character attacks he wasn't prepared for, or stay silent and essentially forfeit his entire self-defense narrative.
The psychological weight of that moment in that room must have been just crushing.
Absolutely.
And he ultimately chooses not to testify.
It's a devastating tactical blow that effectively neutralizes the defense.
I do have to push back a little here, though, on behalf of the state. Because these defense attorneys are highly educated, highly paid professionals. If this Try It Clean agreement was the absolute linchpin of their entire case, isn't it kind of their own fault for not getting it on the official public record?
That's a fair question. Like, why should the appellate court grant a completely new trial for what sounds like a rookie administrative mistake by the defense team.
Well, if we connect this to the broader principles of due process, the legal system recognizes that the state holds a deeply disproportionate amount of power. The defense in this appeal relies on a Supreme Court precedent called Santabello versus New York.
Yeah.
That case establishes a core rule. When the state makes a promise and induces the defendant to rely on it to their detriment, the state cannot legally abandon that promise at the final hour.
Even if the lawyers were sloppy and didn't write it down?
Even then. Because the issue isn't about punishing the lawyers, it's about protecting the fundamental fairness of the trial for the defendant. The state received a massive benefit here. The defense held back their aggressive cross-examination, they held back their medical experts. To then repudiate the deal right when it was the defendant's turn to reap the benefit, it essentially coerces him into waiving his Fifth Amendment right to testify.
Wow, yeah.
It honestly doesn't matter who forgot to hit the record button. If the state induces a strategy-altering reliance and then breaches that trust to silence the defendant, the process is structurally broken.
So the doors to the courtroom are effectively closed to the public. The defense's medical experts are benched. The teenage defendant is silenced. The defense is basically backed into a corner before closing arguments even begin. But the escalation continues.
It gets worse.
It does. The defense argues that it was the judge's instructions to the jury that delivered the final fatal knockout blow to their case.
Yeah, because jury instructions are the critical intersection where the raw facts of a trial meet the strict interpretation of the law.
And here's where it gets really interesting. Because in popular culture, we just think of juries as 12 people sitting in a room deciding what happened based on their gut.
Right, like they just chat about it and vote.
Exactly. But they don't have free rein. They only decide the facts based on the highly specific legal rules the judge hands them right before they deliberate. And the defense claims the judge handed this jury a faulty rule called the provocation instruction.
Now, the law of provocation is incredibly narrow. It essentially means that you lose your legal right to claim self-defense if you intentionally provoked the other person into attacking you, simply so you could have a pretext to use deadly force against them.
So it's like intentionally poking a bear with a stick just so you have a legal excuse to shoot the bear when it charges you?
Exactly that.
But the defense points out in their appellate filing that there was absolutely zero evidence presented at trial that Anthony provoked this altercation as a pretext to hurt the victim. Like, you can't just be involved in a mutual fight. The law requires a preformed design, a specific intent to create the occasion for deadly force.
Right, and providing a jury instruction without a firm evidentiary basis is highly problematic in appellate law. Jury instructions act as the filter through which all testimony and evidence must be viewed.
And the prosecution knew exactly how powerful this filter was. In their closing arguments, they leaned on this provocation instruction heavily. They explicitly told the jury they could use this specific rule to completely throw out the self-defense claim.
Which is incredibly damaging.
It feels like handing the jury a loaded narrative weapon right before they go into the deliberation room, a weapon they legally shouldn't have been given access to in the first place.
It raises profound questions about the purity of the deliberation process. I mean, if the filter the judge provides is legally warped, the resulting verdict is inherently tainted. You cannot give a jury a legal mechanism to dismiss a defense if the foundational facts don't support the use of that mechanism. The defense is arguing that this single unsupported piece of paper destroyed their only viable path to acquittal.
Which brings us to the fourth and final element of this appeal. And honestly, the part of this deep dive that reads the most like a Hollywood legal thriller.
It really does.
The defense is essentially arguing that even if an appellate court looks at the closed doors and the broken unwritten deal and the fatal jury instruction and thinks, well, maybe none of these individually warrant a new trial, the sheer cumulative weight of all of them combined surely deprives a citizen of a fair trial.
The cumulative effect, yes.
But the story doesn't end when the gavel comes down on the verdict. The defense also filed a motion to recuse, meaning they want to legally ban Judge John R. Roach from having any involvement in the appeals process.
And the foundation for that recusal motion rests almost entirely on the judge's own extraordinary post-trial actions.
The sequence of events is just wild. The trial ends. KARMELO Anthony receives a 35-year sentence. The original defense team steps away, and the new appellate lawyers come in to start analyzing the trial for errors.
Right, the appeals team.
So they go to the courthouse to get the official case file so they can actually do their jobs. And they're told they aren't allowed to see it.
Which is baffling.
The judge has sealed the entire case file by an oral order.
which is an incredibly rare and frankly hostile roadblock. A transparent public docket is the absolute baseline requirement of the appellate process.
Right. And the judge tells these new lawyers they can only look at the file inside his chambers, and only if they agree not to disclose what they see to anyone else. It's a complete catch-22.
Oh, entirely.
A defense attorney, obviously, cannot agree to keep the file a secret if their entire job is to write a public appeal based on that file. But while the lawyers are fighting just to see the paperwork, Judge Roach does something that blew my mind when I read the transcripts. Just 2 days after sentencing the defendant, while he still actively holds the power to rule on a motion for a new trial, Judge Roach goes on local television.
Yeah.
He sits down for an on-camera interview with WFAA-TV.
A local news broadcast speaking directly to the general public.
Yes. And on television, he explicitly defends his courtroom access restrictions. He tells the reporter that keeping the cameras and the streaming out was an easy decision. He says he struck a pretty well balance between security and access.
Unbelievable.
And then, when the reporter asks him directly about the jury's verdict, the judge explicitly endorses it. He says on camera, yeah, they did get it right, and states as a matter of fact that the defendant committed a crime.
Wow.
If I could hypothesize for a second here, if a judge goes on television to publicly defend a verdict, it seems to me they are basically becoming a witness or like an advocate for the state.
Yeah.
Doesn't that make it legally impossible for them to act as a neutral referee on the appeal? Like, how does an appellate court actually evaluate judicial bias in a scenario like this?
You've hit the exact legal mechanism on the head. When appellate courts evaluate a motion to recuse, they aren't necessarily tasked with proving that the judge harbors deep secret malice in their heart. The legal standard often hinges on the appearance of bias.
Wow, the appearance of it.
Exactly. The foundation of our entire legal system relies on the judge being a completely neutral arbiter. You cannot publicly vouch for the correctness of your own controversial rulings and publicly endorse a guilty verdict on television while you are simultaneously the person sitting on the bench tasked with objectively deciding if that very trial was constitutionally flawed.
You literally cannot grade your own homework on the evening news on Tuesday and then pretend to be an objective grader in the courtroom on Wednesday.
It completely destroys the appearance of neutrality. The defense argues, and the law generally supports this idea, that a reasonable member of the public would severely doubt that a judge who is publicly committed to the fairness of a trial could then impartially weigh a defense motion asking him to declare that same trial unconstitutional. The well is poisoned.
It is just a staggering escalation of events to review. So let's briefly recap the 4 core claims we've analyzed for this retrial demand. First, the escalation began at the courthouse steps with a secretly closed courtroom where the public was walled off by pre-dawn curfews and bait-and-switch overflow rooms. Second, the secrecy bled into chambers with a broken, unrecorded handshake agreement that coerced a teenage defendant into silence and gutted the defense's medical evidence.
Yep.
Third, the unsupported provocation instruction that handed the prosecution a fatal legal weapon to defeat the self-defense claim in the deliberation room. And finally, the crushing cumulative weight of all these structural errors, topped off by a presiding judge going on the local news to defend his actions and endorse the conviction before the appeal process had even begun.
And it is vital to understand that these aren't just obscure technicalities or bureaucratic missteps. These procedural rules, the open doors, the binding agreements, the accurate instructions, the neutral judges, they exist to protect everyone, including you, the listener.
Exactly.
They are the structural guardrails of liberty. If the state is permitted to close the doors without justification, break unwritten deals without consequence, and issue unsupported instructions that tip the scales of justice, the system fails us all. The process is the punishment, and the process must be fair.
Which brings us right back to where we started today. We inherently expect our grand monuments of justice to be transparent. But I want to leave you with a profound paradox to mull over as we wrap up.
Okay.
The judge in this case issued a sweeping 10-month gag order that legally silenced everyone involved, with the stated noble goal of protecting juror impartiality and ensuring a fair trial. But then, literally days after the sentence is handed down, that exact same judge goes on television to declare the jury got it right, while the defense's motion for a new trial is still sitting pending on his desk. If the grand public monument of justice has its doors locked and its windows tinted to keep the public out, but the architect of the trial is outside giving press conferences about how perfect the building is, who is really protecting the integrity of the court?
That is the question.
Thanks for joining us on this deep dive. We'll catch you next time.
Welcome to this explainer. We're jumping straight into a massive legal controversy that actually strikes at the very heart of the American justice system. We're looking at the high-profile murder trial of Carmelo Sincere Anthony. Now, this case ended with a conviction and a 35-year sentence, but right now, the spotlight isn't just on that verdict. It's on the courtroom itself. The defense has filed a motion for a new trial, and they are alleging a severe structural public trial violation. They're arguing that the way this trial was administered fundamentally shut the public out. And we really need to break this down, because an open courtroom isn't just about one single trial, right? It is an absolute bedrock of democracy, designed to ensure transparency for all of us.
To truly wrap our heads around this legal argument, we have to ask a very practical, real-world question. What actually happens to constitutional transparency when a trial of this magnitude, one drawing huge national attention, collides with the strict physical limits of a local courthouse? How is a judge supposed to balance courtroom security and decorum with the Sixth Amendment right of the public to actually witness justice being served? Well, according to the defense's motion, the balance struck in this specific case crossed a very dangerous line. They argue it went from standard administrative management straight into unconstitutional secrecy.
Okay, so let's unpack this core concept. The defense is claiming a structural public trial violation took place. Basically, the Constitution demands that if a judge is going to close a courtroom to the general public, they have to pass what's known in the legal world as the Waller test. This means the judge has to make specific, on-the-record findings that justify closing the doors, and they absolutely must consider reasonable alternatives first. But the defense argues that through a maze of administrative rules, the court functionally closed this trial without ever meeting those strict, mandatory legal standards.
Let's kick things off with Section 1, secrecy before the trial.
You see, the public's exclusion didn't just magically begin on the first morning of jury selection. According to the defense, the groundwork for a closed-off process was actually laid way before anyone even stepped foot inside the courthouse. Over 10 months before the trial, the court issued a massive, sweeping gag order. And what's really notable here is that the judge issued this sua sponte, which means he did it entirely on his own accord. Neither the prosecution nor the defense actually asked for it. This order silenced pretty much everyone involved: parties, witnesses, law enforcement, even court staff. They were banned from discussing the character of anyone involved, expected testimony, or the evidence. If you wanted to talk to the news or post on social media, you had to get explicit written approval from the judge. It was an incredibly tight lid, and it was backed by the threat of contempt, fines, and attorney discipline.
And while that gag order kept all the participants completely quiet in public, the actual, substantive, legal heavy lifting of the case was moving behind closed doors. The defense points out that crucial pre-trial negotiations were held entirely off the public record, quite literally inside the judge's chambers. This even included a pivotal, unrecorded evidentiary agreement about character evidence that ended up profoundly shaping the entire defense strategy. So think about it. If a regular member of the public had checked the public docket before the trial started, they would have found absolutely no hearings to attend and no substantive pretrial motions to read. The public record was effectively completely dark. Moving right along to Section 2, the seat math and visualizing scarcity.
When you're dealing with a trial that has the whole nation watching, the physical space obviously becomes your first major bottleneck. And the basic arithmetic of the 296th District Courtroom is incredibly revealing here. Out of roughly 70 total seats in the room, the general public was left with a surprisingly tiny slice of the pie. The court-appointed public information officer allotted 15 seats to the prosecution's family, 15 to the defense's family, and 9 to the media. Once you factor in all the necessary court staff, that left only about 24 rotating seats for the general public. And to make matters worse, the defense notes that even those allocations weren't strictly honored. For instance, the defendant's own family was capped at just 8 seats in practice, which meant his grandfather and aunts couldn't get in. This math created an absolutely massive scarcity for the public.
Which brings us to Section 3, the pre-dawn lottery and curfew.
So if you've only got about 24 public seats for a nationally watched trial, how on earth do you decide who gets them? Well, the court managed this extreme scarcity by requiring folks to navigate a daunting maze of logistical hurdles. Right before the trial, the court enacted an overnight curfew on the entire courthouse campus, running from 11 p.m. to 6 a.m. The rules dictated that the public doors would open at 8:50 a.m., but astoundingly, they locked promptly at 9 a.m. If you were actually lucky enough to snag a seat, you couldn't leave and re-enter unless there was an official recess. On top of all that, the court imposed a strict ban on anyone wearing clothing deemed distracting. That is a highly subjective rule, adding just one more hurdle to observing a high-stakes murder trial.
The absolutely crucial point here is that this setup left members of the general public with exactly a 10-minute daily window to enter the courtroom. Just 10 minutes, from 8:50 to 9 a.m. If you arrived at 9:01, you were totally locked out until the next recess. But let's be real, with only about 24 seats available, showing up at 8:50 a.m. meant you had virtually zero chance of actually getting inside. Because of that strict curfew and the severe lack of seats, the actual queue, the true line that determined who would get to see this trial, formed hours before dawn. The defense details how everyday citizens began lining up between 4 and 5 in the morning at the edge of the courthouse parking lot, just waiting in the pitch dark for this 6 a.m. curfew to lift. These are just average citizens trying to access their justice system, but instead they're subjected to a pre-dawn lottery administered by sheriff's deputies. The defense points out that this line was managed without any published standards. People who had waited for hours in the dark were sometimes suddenly displaced by individuals claiming media credentials, meaning the public's few seats were completely exhausted before the sun even came up.
Now for Section 4, the vanishing overflow room. Usually, a court with limited seating can easily set up alternative viewing accommodations. And initially, this court actually did. But the very core of the defense's constitutional argument hinges on a sudden, completely unexplained overflow bait-and-switch. On May 29th, the public information officer announced that an overflow room with a live feed would be available. On June 1st and June 3rd, during jury questionnaires and voir dire, an auxiliary room was successfully utilized by the public. But then on June 4th, the exact day the actual witness testimony began, the overflow room was eliminated entirely. No prior notice, no public hearing, and absolutely no on-the-record findings from the judge.
And the defense wasn't just speculating here, they had the receipts. They anchored their claims in documented reality, pointing directly to emails from the court-appointed public information officer. When people who had literally flown in from out of state, folks from Arizona and North Carolina, asked where they could watch the trial after being turned away from that tiny courtroom, the official response was stark. In writing, the official stated, "There is no overflow room." That means for a trial of immense public interest, there were exactly 0 overflow seats, 0 live audio feeds, and 0 video live streams available to the public once the testimony actually kicked off. The court simply did not broadcast the proceedings to anyone who couldn't secure one of those roughly 24 physical seats during that tiny 10-minute morning window. The bitter irony here is that the constitutional accommodation existed only when no witness was actually testifying. Television monitors were set up and audio was provided for jury selection. But the exact moment the state began presenting its core evidence against the defendant on June 4th, the overflow just vanished. Lines of 80 to 100 people outside resulted in only a tiny fraction being admitted. And this total blackout remained in effect through the closing arguments, the guilty verdict, and the swift imposition of a 35-year sentence. Which brings us to our final section, Section 5, Seeking a New Trial. All of these compounding administrative restrictions, the gag orders, the off-the-record chambers meetings, the 10-minute entry window, the pre-dawn parking lot lines, and that vanishing overflow room, all of it culminated in the defense taking decisive legal action. They formally filed a motion for a new trial based on a structural error, arguing that the court completely bypassed that Waller test we talked about earlier. Remember, a judge is totally allowed to manage their courtroom, but if their rules foreseeably exclude the public, they have to justify it on the record and consider reasonable alternatives, like, just keeping the audio feed turned on. Because the court bypassed these constitutional safeguards, the defense argues this isn't just a minor procedural glitch. It's a structural public trial violation that demands the entire judgment be set aside. Now, you know what's really interesting? Following the trial, the judge publicly defended his restrictions in a televised interview with a local news station. He called the decision not to stream audio or video an easy decision, and remarkably stated that he felt he struck that balance pretty well, asserting that the public could have just stood in line with everybody else. As you can imagine, the defense is now utilizing these very public statements to further highlight that the denial of alternative access was a deliberate choice by the court, not just some unavoidable logistical accident. So this leaves us with a truly profound legal question to consider, one that the appellate courts are likely going to have to answer soon. At what point do severe administrative hurdles to physical seating effectively violate the constitutional guarantee of a public trial? If everyday folks have to wait in a parking lot at 4 a.m. for a handful of seats with no digital overflow provided whatsoever in the modern era, is that courtroom genuinely open? It's a fascinating look at where day-to-day logistical management collides with the absolute bedrock principles of American justice. So what do you think? Thank you so much for joining me on this explainer. Keep questioning, keep learning, and I'll catch you next time.
So if you were to walk into a murder trial today, you'd probably expect a lot of yelling, right? Like gavel banging and surprise witnesses just bursting through the back door.
No, definitely, like straight out of a movie.
Exactly. I mean, we are so conditioned by television to expect this really noisy, chaotic collision of drama. But the real machinery that actually decides a person's life or death.
It's completely different.
Right. It usually happens in this complete clinical silence. So welcome to today's deep dive. We are actually opening up a raw, unedited court transcript today to look at the hidden architecture of the justice system.
Yeah, and the document we're unpacking, it's volume 7 of a court reporter's record.
Yeah.
This is from the 296th District Court down in Collin County, Texas.
And the date on this is June 8th, 2026.
Right. And the case is the state of Texas versus Carmelo Sincere Anthony.
So to give you a little context, we are looking at an incredibly high-stakes jury trial here.
Very high stakes. It centers around a fatal stabbing that took place at a high school track meet.
Which is just an intense scene to imagine.
It really is. I mean, you have teenagers, a crowded public setting, and obviously a murder charge. So it creates this inherently volatile environment right from the start.
But our mission today isn't to play armchair detective, right? We aren't going to sit here and debate the witness testimony or try to figure out what actually happened on that track field.
No, not at all.
Instead, we're focusing entirely on two, really pivotal behind-the-scenes moments. These are moments that happen away from the jury's eyes and then right before the jury goes to work.
Yeah, we're looking at the guardrails.
Exactly. The heavy, rigid guardrails the legal system uses to basically manufacture a fair trial. Specifically, we're going to look at the judge's intense instruction to this teenage defendant about his right to testify.
And then after that, the incredibly strict, literally life-altering instructions given to the jury right before they begin their deliberations.
Reading through this transcript, it feels a lot like getting a backstage pass to an operating room.
That's a great way to put it.
You know? You get to watch the raw mechanics of the Constitution being applied in real time. It just strips away all the theatrics to show you the clinical rules that govern everything.
Yeah, and the scene in the courtroom for this first part is incredibly stark.
Oh, completely. The jury has been cleared out. The public gallery is totally empty.
Right, so the only people left in the room are the judge, the prosecution, the defense attorney, the defendant Carmelo, and his parents.
Just them in this massive room.
Exactly. And the defense is trying to decide whether Carmelo is going to take the witness stand.
Which is a huge decision. And immediately, we see this really fascinating piece of legal maneuvering happening in the shadows.
The gentleman's agreement.
Yes. The defense attorney and the prosecutor actually reveal to the judge that they've struck a gentleman's agreement regarding Carmelo's testimony.
Yeah, so they lay out this sort of quid pro quo for the judge. Essentially, the lawyers agreed that if Carmelo takes the stand and testifies strictly about the physical facts of what happened that day.
Like just the sequence of events.
Right, just the facts of the track meet. If he does that, the state promises not to bring up Carmelo's past character or his extraneous reputation.
Okay, then in return.
In return, the defense promises they won't attack the victim's character.
Wait, let's pause there for a second. Because when they say extraneous reputation, what does that actually mean for the jury in a situation like this?
Well, it's a really critical concept in evidence law. Extraneous refers to past mistakes, prior bad acts, or just general character traits that fall entirely outside the specific crime being tried.
So things he might have done in the past.
Exactly. In a criminal trial, character evidence is incredibly dangerous. Like, if the jury hears that a defendant has a history of starting fights, for example.
They might just judge him on that.
Right. They might convict him simply because they think he's a bad person, rather than because the prosecution actually proved beyond a reasonable doubt that he committed this specific murder on this specific day.
Wow. Okay, so the defense attorney is desperately trying to thread a needle here.
Trying very hard, yes.
He wants Carmelo to be able to tell his side of the story. Maybe he claims self-defense, or maybe it was a terrible accident, without opening the door for the prosecution to just assassinate his character using his past.
You nailed it.
So it's kind of like two boxers meeting in the middle of the ring before the bell rings, right? And they whisper to each other, "Look, I won't hit you in the face if you don't hit me in the face."
That's a really good analogy.
They're trying to create their own custom rules for the fight. But then the referee, which is the judge here, steps in and explicitly says, if you step into this ring, the actual rules of boxing apply no matter what you just whispered to each other.
That captures the exact mechanical problem we see in the transcript. The judge warns the lawyers very bluntly that a gentleman's agreement in a criminal case is legally fragile.
Because it's not a civil case.
Exactly. He explains that in a civil case, say a dispute over a business contract or a property line, the two parties are basically private actors resolving a private dispute.
Right, it's just between them.
Yeah, so they can make legally binding contracts about how the trial will proceed, what evidence to skip, whatever, and the court will usually enforce those agreements.
Because the stakes are just money or property.
Exactly. But a criminal trial is a completely different beast.
It's the state versus an individual.
Right. A criminal trial is the state seeking to uncover the absolute truth of a crime using a very rigid set of statutory rules of evidence. You cannot just casually contract away the pursuit of truth.
Oh, wow.
Yeah. So the judge tells the defense attorney, look, if the state breaks this gentleman's agreement during cross-examination and starts asking Carmelo about his past character anyway,
The judge can't stop them.
the judge cannot force the prosecutor to stop based on their backdoor deal. The judge will have to rule based strictly on the law of evidence.
Which completely changes the calculus for the defendant. I mean, the judge is looking at this teenager and saying, if you get on that stand, you are stepping out onto the ice. I cannot guarantee the ice won't break just because the prosecutor promised to tread lightly.
It's a huge gamble.
It sets up this massive, unpredictable risk. And because that safety net is legally void, the judge has to address Carmelo directly.
And this brings us to one of the most profound moments in the transcript, really.
Yeah, it really is.
The judge basically puts the lawyers in the background and speaks directly to Carmelo. He swears him in outside the presence of the jury to give him a formal admonishment.
Just a one-on-one conversation.
Right, and we get to see the bedrock of the American legal system, the Fifth Amendment, explained in practical life or death terms.
The judge explains this protective shield of silence. He assures Carmelo that if he decides not to testify, it absolutely cannot be used against him.
Right.
But, you know, what strikes me about this is the incredible psychological weight of that rule. Because human nature dictates that if someone stands up in a room and publicly accuses you of doing something terrible,
You want to fight back.
exactly, your immediate visceral instinct is to speak up and defend yourself. If you stay quiet, society generally assumes you're hiding something.
Right, the whole, if you have nothing to hide, you have nothing to fear mentality.
Exactly. Yet the court is imposing this artificial clinical rule that completely overrides human nature.
It requires a massive leap of faith. I mean, you are asking a defendant to sit completely motionless in a chair, sometimes for weeks, while witnesses point fingers at them.
Yeah, just sitting there.
And they have to trust that the system will actually protect their silence. And to reinforce that trust, the judge points out exactly how the jury will be instructed.
What does he tell him?
He tells Carmelo that the jury will receive a strict written directive. They cannot go into the deliberation room and say to each other, well, if he was innocent, he would have gotten up and told us.
Wow, so they are explicitly forbidden from even thinking that out loud.
Exactly. His silence cannot be treated as a fact or a circumstance against him for any reason whatsoever. It is a total legal override of human suspicion.
But let me push back on how this actually plays out on the stand, though. Because say a defendant does want to tell their story, but they are just terrified of the prosecutor.
Which is very common.
Right, so can't a defendant just take the stand, answer their own friendly lawyer's questions to get their narrative out there, and then the second the prosecutor stands up and starts asking the tough, character-destroying questions, just plead the fifth?
Oh, that is a very common misconception. But the legal mechanism absolutely forbids it.
Really? You can't just stop talking.
No, you can't. The legal doctrine operates on the principle that you cannot use the Fifth Amendment as both a sword and a shield simultaneously.
Okay, what does that mean in practice?
It means you cannot use your testimony as a sword to attack the prosecution's case and then pull up the shield of silence the moment they try to test your credibility.
Oh, I see.
And the judge is incredibly firm in unpacking this for Carmelo.
Yeah, the phrase he uses in the transcript is, you cannot refuse at that point and say, okay, I'm going to plead the fifth now. You have to answer those same questions.
It's an all or nothing switch.
The moment you waive your right to remain silent, it evaporates entirely for the duration of that trial.
In legal terms, we call this opening the door.
Opening the door, okay.
Right, so if Carmelo gets up and testifies about the track meet, he opens the door for the state to cross-examine him, not just about the timeline, but about anything relevant to his credibility, his state of mind, or his character, depending on how he answers.
Everything is fair game.
The judge warns him that from the moment he opens his mouth, the state can use everything he says for, against, or neutral to him. It is literally open season.
That is, I mean, you are placing an unfathomable burden on a kid. You're asking a teenager to sit in that chair and maintain total emotional composure under cross-examination by veteran prosecutors.
People who dismantle people for a living.
Exactly. The pressure in that room must be suffocating.
It is, and the system recognizes that pressure, which is why the judge ends this admonishment with a vital reminder of personal autonomy.
Reminding him it's his choice.
Yes. The judge acknowledges that Carmelo has an experienced legal team advising him, and he notes that Carmelo's parents are sitting right there in the room. But he emphasizes that when all the advice is given, the choice is Carmelo's and Carmelo's alone.
Nobody else can make it.
No lawyer, no parent, no judge can make this decision for him. It is a deeply personal, non-delegable constitutional right.
So then, the judge grants a brief recess. He tells Carmelo to go step out, go to the restroom, talk to his mom and dad, talk to his lawyers one last time without the court watching.
Gives them some breathing room.
Right. And when they finally come back on the record, the judge simply asks for the decision. And Carmelo Sincere Anthony tells the judge, quote, "I don't want to testify."
And that single sentence just freezes the entire trajectory of the trial.
It's a huge turning point.
It is. The moment he invokes that right, the evidentiary record is locked. No new facts can be introduced by the defense.
So because the defendant chooses silence, the defense rests. The state officially closes the evidence. The trial phase, as we normally think of it, is just over. And suddenly, the spotlight swings aggressively away from the lawyers and the defendant, and it lands squarely on the 12 people sitting in the jury box.
The focus shifts entirely to preserving the integrity of those 12 minds.
Yeah, the people who will make the final decision.
And the transition here is crucial. Think about it. The court has spent days, maybe weeks, carefully curating exactly what information those 12 people are allowed to hear.
Filtering out everything extraneous.
Right. So now the court has to ensure that nothing from the outside world contaminates that carefully curated bubble before they reach a verdict.
So the judge dismisses the jury for the evening so he and the lawyers can prepare the charge of the court.
Which is that highly complicated, thick packet of final legal instructions.
Right, the rules that will guide their deliberations. But before he lets the jury go home, he drops an absolute bombshell on them about what is going to happen the next day.
Oh, this part is intense.
He tells them that once closing arguments are over and deliberations begin, they are going to be sequestered.
Yeah, sequestration is one of the most extreme, disruptive tools the justice system possesses.
It really sounds like it.
It is not used lightly. But in highly publicized, emotionally charged, or volatile cases like a fatal stabbing at a public high school event, it becomes a mechanical necessity to protect the verdict from being tainted.
Well, when you really look at the mechanics of sequestration, I mean, you are taking everyday citizens who were simply called for civic duty and legally severing their connection to the outside world.
Like a 1990s sensory deprivation retreat, but with the highest possible stakes.
That is the perfect way to describe it. The judge outlines these draconian rules they're about to face. He tells them they will be taken to a hotel until they reach a verdict.
But not just a normal hotel stay.
Right. He explicitly says, and I'm looking at the transcript, the problem with the rules of the hotel are you will have no TV, you will have no phone, you will have no access to your own phone.
Just consider the immense psychological weight of that isolation for a second.
It's terrifying.
They aren't just losing entertainment, right? They were losing their connection to their families, their jobs, their entire support network.
What happens if there's an emergency?
Well, the judge explains that their families will only be given a secure emergency number to call the bailiffs in case something catastrophic happens at home, but otherwise, they completely cut off.
It creates this profound sense of legal claustrophobia. You have 12 people holding another human's life in their hands, locked in a hotel without a single screen to look at.
Just left with their thoughts and the evidence.
And the system is so terrified of outside contamination that it's willing to impose this massive psychological burden on innocent jurors just to ensure the airlock remains sealed.
It is brutal.
Yeah.
But there is a surprisingly human moment from the judge right after he drops this terrifying prospect on them.
Yeah, he kind of softens the blow.
He does. He recognizes how agonizing that isolation will be. So he tells the jury that instead of ending the court day at 5 o'clock like a normal business day, he actually plans to keep them working in the deliberation room late into the night.
Like until 10 or 11 o'clock.
Exactly.
And his reasoning is so incredibly pragmatic. He tells them, if we stop at 5 o'clock, all you are going to do is go to a hotel and sit there and stare at the ceiling, so we might as well be here and continue to work.
He's just being honest with them.
He's trying to save them from the agonizing boredom of a phoneless, TV-less hotel room. It paints such a vivid, bleak picture of what the justice system demands of its citizens.
It's an act of mercy, really, but it also serves the court's purpose.
How so?
Well, keeping them focused on the task at hand prevents their minds from wandering. It prevents frustration from building up in isolation. And ideally, it moves them closer to a resolution faster.
That makes a lot of sense. And that leads to the judge's final crucial warning for that evening. Before he sends them home to pack their overnight bags, he issues a strict directive about their behavior for the next 12 hours.
The ultimate gag order.
Yeah. They are not to discuss the case with anyone, not their spouses, not their kids.
And most importantly, not even each other.
Which has to be so hard.
Oh, the temptation to debrief after days of stressful testimony is overwhelming. The judge knows this.
You just want to vent.
Exactly. But he explicitly warns them against the natural urge to bounce ideas off of each other in the parking lot or the hallway. The law requires that all deliberation happens inside that single room, with all 12 jurors present, only after they have received the final legal instructions.
He ends with a plea that I think just summarizes the entire weight of this raw transcript. He looks at this jury and says, "We've come so far and we've worked so hard, all of us. Let's don't blow it."
That phrase, "let's don't blow it," it really highlights the extreme fragility of a criminal trial.
It really does.
Think about the resources invested to get to this exact moment. The millions of dollars spent, the years of police investigation, the days of expert testimony.
The agonizing emotional toll on both the victim's family and the defendant's family.
All of it. That entire monumental pursuit of justice can be instantly derailed, completely thrown out, and forced to start over if a single juror casually looks at a tweet about the case or texts their spouse asking for an opinion on a witness.
Just one text could ruin it?
Yep. The system demands total, absolute purity at the finish line.
You know, this deep dive really pulls back the curtain on what a trial actually is. We started by comparing it to a sterile operating room, and this transcript proves it.
The proof is right there in the text.
The hidden architecture isn't about dramatic confessions or explosive evidence. It's about the clinical, almost surgical rules designed to maintain an artificial environment.
It's a highly controlled experiment.
Exactly.
Okay, and we're going to stop right there because, as they said, it's a highly controlled experiment. The one thing that I do beg to differ with is the last analysis of them saying that, oh, the judge basically gave them a break from being trapped in the hotel board. It seems like, you know, like I said, it was forced. He was putting pressure on the jurors saying, hey, well, you know what, we might as well just work to 11 o'clock at night, you know. So there was a lot of outlandish things that were done by this judge. And I want to say thank you so much for re-listening to, or if you have not got a chance to, the AI podcast that I was able to put together to break down the last 2 days of the trial, as well as the motions for recusal and is it for a new trial. Okay, so we looked into that. Now, as you can see on the screen, no one really has live feeds because they're not going to be inside live feeds, so they'll be coming in and out. As you see, I'm going to be keeping my eye on a few of these content creators. The channel that we were watching, Time News Now, I believe that's where we're at, right? Time Now New World, I do apologize. Time Now World, they will be back at 1 o'clock. That's when I believe it may be over. So with that goes to say, I may be reporting back a little bit after that time, or we'll just save it for a deep dive. I do want to say thank you so much for being here with Miss Grace. Getting ready for some good news. We're just going to pray that it is good news for Carmelo, and then we're going to take it from there. I want to say thank you so much. Please hit the like button. As you know, I am not monetized. I will not be not monetized. Okay. And all I want to do is just spread the truth, unbiased truth, and connect as many people to God as possible. Please hit the like button. Love and blessings to Carmelo Anthony, and happy birthday to Nolan Wells.
I could not be here breathing and be comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long.
I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't.
Boys, I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
Shut it down, baby. Let's go off with this one.
Jesus,